Colorado versus James Egan Holmes, case number 12CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, and the prosecutors are present as well. Dr. Reed is present as well. Let me address the bench conference that we had at the end of the morning session. And for the record, the jury has exited the courtroom. In fact, the jury did so before the lunch break, and so that we are outside the presence of the jury. Is anybody asking that Dr. Reed step out, or is everybody okay with us having this discussion in his presence?
I think he should not be present, Your Honor.
All right, let's have him step out for just a moment. Doctor, if you don't mind. All right, for the record, Dr. Reed has now stepped out of the courtroom. The question that drew an objection was as follows. Was it also part of that standard that you're going to apply to this, that the defendant suffered from a mental disease or defect that prevented him from forming the intent to commit murder after deliberation? Dr. Reed then answered in a non-responsive manner that his opinion is that whatever the defendant suffered from, it did not prevent him from forming the intent and knowing what he was doing and of the consequences of what he was doing. During the lunch break, I went back and reviewed People versus Herrera, which is published at 87 Pacific 3rd, 240, Colorado Court of Appeals case from 2003, which was discussed in my order D-246. As relevant here, Herrera and other cases such as People versus Herdman, Herdman, 310 Pacific 3rd, 170, Colorado Court of Appeals 2012, and People versus Bondurant, Bondurant, 296 Pacific 3rd, 200, Colorado Court of Appeals 2012, make clear that sections 16-8-107, subsection 1A, and subsection 1.5A limit the admission of information obtained during a court order examination to the issues that are raised by the plea of not guilty by reason of insanity. Therefore, a court-appointed sanity examiner cannot testify as to the ultimate issue of the defendant's culpability or guilt, or as to whether the defendant actually acted with the culpable mental state that is an element of a crime charged. By the way, that's consistent with the limiting instruction that we all have agreed I have to give the jury in this case, and that is that the jury may consider certain evidence only for the limited purpose of assessing the issues raised by the insanity defense. And more specifically, that instruction applies to information obtained for the first time during a court order examination. So what are the issues raised by the insanity defense? Well, I think to answer that question, you have to look at the definition of insanity. And the applicable test of insanity in Colorado is a two-part test. Number one, a person who is so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act is not accountable. Or, number two, a person who suffers from a condition of mind caused by mental disease or defect that prevented the person from forming a culpable mental state that is an essential element of a crime charged. And notice that the first prong of that test uses the term incapable, while the second prong uses the term prevented. I read those to convey generally the same meaning, and that is that I understand the use of the word prevented in that second prong of the test to refer to as not being able or capable of forming a culpable mental state, as opposed to not actually forming a culpable mental state. The language that was used by Mr. Brockler in his question and by Dr. Reed in his answer is consistent with the second prong of the test that I just read, the insanity test that applies in Colorado. In fact, Mr. Brockler used prevented instead of incapable when asking about the first part of the test. And I know that he wasn't asking Dr. Reed to give an opinion. He was asking Dr. Reed about the standard that applies. And in asking about the first prong of the test, he used the word prevented as well instead of incapable. And there was no objection to that question. And again, I think that term is similar, at least as used in the statute, to incapable. I think incapable and prevented are used similarly in the statute. So after looking at Herrera, looking at the statute that I cited a moment ago over the lunch break, I have concluded that there has been no violation of Order D-246 and that there has been no improper testimony. Therefore, the motion to strike, the answer is denied, and the motion for a mistrial is likewise denied. Now, having said all that, let me address the defense's concern. I do think that someone could misunderstand the use of the term prevented to imply that the defendant actually formed a culpable mental state required by a crime charged. And so I think counsel and the witnesses should avoid the term. Instead, I think the terms capacity or capable or incapable should be used because they make it clear that what the witness is talking about is whether someone has the capacity to form a mental state as opposed to whether someone actually formed a mental state, a particular mental state. And then the last thing is that I think it's appropriate to have Mr. Brockler clarify with Dr. Reed what he meant. And I think it should be clear to the jury that Dr. Reed is not opining about whether the defendant actually distinguished right from wrong or whether the defendant actually formed a culpable mental state that is an element of a crime charged. It should be made clear that what he's opining about is whether the defendant was so diseased or defective in mind as to be incapable of distinguishing right from wrong, and he is opining about whether the defendant suffered from a mental disease or defect that rendered him incapable of forming a culpable mental state that is an element of a crime charged. I think that makes it very clear, and I think that avoids any misinterpretation, and I think that's consistent as well with the statute that I have cited, and it's consistent with Herrera and the other case law. So, are there any questions at this time? And I'm going to give Mr. Brockler a chance to speak to Dr. Reed to clarify this and to make sure he understands that Mr. Brockler has been asked by the court to have him clarify what I just indicated should be clarified.
Thank you, Your Honor. I'll do that. I just want to say to the court and the counsel, too, I may do a little bit of leading through this minefield just to make sure that we don't have any other missteps in this particular area.
I'll give you some leeway, and if at some point Mr. King thinks that it's going too far and he wants to object, then I'll let him object. But I think for purposes of discussing the legal standard, I think it's probably the safest route to go. I think once you get into his actual opinions and other things, then obviously it would be unnecessary and improper to continue to lead, but I'll give you some leeway for now, so you may lead. And I'll ask you to make sure you clarify with him what I just indicated should be clarified. Does it make sense, what I said needs to be clarified?
Yes, sir, it does.
Okay. All right, the other thing is, I need to give the jury a limiting instruction, right? Don't I need to give the jury the limiting instruction? Does it make sense to give it to them now? To give the jury the limiting instruction I've been talking about how it may only consider this evidence as to the issues raised by the defendant's plea of not guilty by reason of insanity?
Yes, sir.
All right. Mr. King, anything from you at this time?
I'm sorry, Judge.
Anything?
Yes, Judge.
Yes,
May
go
I,
ahead.
May I go to the podium?
Yes, please.
Judge, and I apologize if it was a little confusing when we approached the bench, because I initially meant to object to the initial question that Mr. Brockler asked. And that question was, and I began to make that argument when I was at the bench, and then the Herrera issue kind of took over. But There's two issues here, Judge, and the first question Mr. Brockler asked is it your understanding that the standard to be applied under Colorado was to determine whether or not the defendant suffered from a mental disease or defect that prevented him from knowing right from wrong, both legally and morally? And as the court just noted, there's the prevented language is concerning to us under the Herrera case. But also, Judge, we believe that the standard in Colorado is not that the defendant was prevented from knowing right from wrong, both legally and morally, but that the defendant was incapable of understanding the difference between right and wrong from a societal perspective of morality. And that's pursuant to the Serrano case. And Judge, we argued in D246 that the issue of legal in understanding legally whether something is right or wrong was irrelevant to the consideration of sanity, and the court disagreed with us. And the court, under Gallimanis and Serrano, said that found that it was relevant as part of the general assessment of what the societal standard of morality is under the Serrano case, and noted it in Gallimanis such a clarifying instruction, clarifying that it's the societal moral standard that is the standard in Colorado, was not needed in the Gallimanis case as it was in the Serrano case. I would distinguish this case from the Gallimanis case in this way, Judge. In the Gallimanis case, the defendant was asserting that he was acting on impulse, was completely divorced from reality, that there was no mental process going on at all. And the court found in that situation that a clarifying instruction was not required. Because the defendant wasn't asserting any kind of morality that was different, or that they were being commanded by delusions as they were in the Serrano case. This is a completely different situation here, Judge. It's just much more akin to the Serrano case. And so I think that is an inappropriate standard, and I think the court needs to clarify with the jury what the appropriate standard is now. And we need to give a clarifying instruction to the jury that the appropriate standard for sanity in the state of Colorado is that the defendant, under prong one, was incapable due to a mental disease or defect from being able to distinguish between right and wrong from a societal perspective of morality. And it's very clear that if a clarifying instruction needs to be given, that's the instruction that needs to be given, and that's the state of the law and the standard in Colorado. I agree with the court that the legal issue may bear on the relevance of the sanity issue in general, and may bear on what society feels the moral standard is between right or wrong. But when we're talking about what the standard is in the state of Colorado, I feel like the jury has now been misinformed, because the answer to that question was yes. And that was followed up by the next question: was it also part of the standard that you're going to apply to this, that the defendant suffered from a disease or defect that prevented him from forming the intent to commit murder after deliberation, which then compounds the problem by calling for an inappropriate response under the Herrera case, as the court has already noted. So in my mind, there are two problems here, Judge, that need to be corrected. And I would stand on our request and record with regard to the Herrera issue. I think that there has been a violation of D246. We would ask that the question and the answer be struck, and that the jury be informed that they were improper. But I would also ask that the court issue a clarifying instruction to this jury at this point, because at this point it's certainly unclear from a jury's perspective what the appropriate standard is. And I think the risk of them being misinformed and misunderstanding at this very early stage what the appropriate standard that they're going to have to base their decisions on in this case is very high, Judge. So that's my record that I needed to make. Thank you.
All right. In terms of the first part of the argument with respect to the issue that came up in Herrera, I've ruled on that, and it doesn't make sense to me to tell the jurors that certain evidence is being admitted for the limited purpose of considering the issues raised by the not guilty by reason of insanity plea, and then give them the definition of insanity, which I've given them, and then say, oh, but an expert can't talk about one of those parts of the definition of insanity. That is contradictory. So I don't think that is appropriate. I don't think that there's anything wrong with what was asked or with what was testified to earlier. I think that there is a possibility of a misinterpretation, and for that reason, I have indicated that Mr. Brockler should clarify things, and I've also indicated that counsel and the witnesses should stay away from using that terminology in the future, but I don't think there's been anything improper, and certainly nothing that rises to the level of a mistrial. In terms of the second issue, I didn't understand your objection to refer to that before the lunch break, and so I haven't had time to think about that. To the extent that it's a request to reconsider Order D-246, I wish you had brought it up earlier, because it would have given me time to think about it. So let me take a quick look at Order D-246.
Your Honor, while the court's doing that, could we speak with Dr. Reed about the court's prior ruling?
Yes.
And Judge, just so that the court's clear, I'm not quibbling with the court's order in D-246. I'm merely stating that the standard that's now before the jury is incorrect.
Okay, let me read D-246. All right, I'm looking at the model criminal jury instructions. And in comment number 3, following instruction I-01, the affirmative defense of insanity, it states as follows: the phrase incapable of distinguishing right from wrong is not defined by statute. And then it cites People versus Serravo, SERRAVO, 823, Pacific 2nd, 128, Colorado Supreme Court case from 1992. In that case, the court provided the following guidance: a clarifying instruction on the definition of legal insanity, therefore, should clearly state that as related to the conduct charged as a crime, the phrase incapable of distinguishing right from wrong refers to a person's cognitive inability due to a mental disease or defect to distinguish right from wrong as measured by a societal standard of morality, even though the person may be aware that the conduct in question is criminal. Any such instruction should also expressly inform the jury that the phrase incapable of distinguishing right from wrong does not refer to a purely personal and subjective standard of morality. And then Mr. King is right. Subsequently, in People versus Galimanis, Galimanis, 944 Pacific 2nd, 626, Colorado Court of Appeals case 1997, a division of the Court of Appeals rejected as erroneous the suggestion that the clarifying instruction that I just read is required in all insanity cases. The court reasoned that in context it is apparent in Serravo that when the Supreme Court noted that a clarifying instruction on the definition of legal insanity should clearly state that right from wrong is measured by a societal standard of morality, it was referring only to instances when a clarifying instruction was necessary. Further, applying this reading of Serravo to the facts of the case at hand, the division in Galimanis concluded that a clarifying instruction was not warranted because, 1, the defendant did not contend that his actions were justified under his own moral beliefs or moral code, nor did he assert that he was conscious that what he was doing was right or wrong, either legally or morally. And 2, he provided no evidence that he was commanded by God to kill the victim. So the question for the prosecution is whether it has a position on the clarifying instruction that was given in People versus Serravo and the court providing that to the jury. Yes.
And while they're conferring, Judge, that was precisely the instruction that I'm asking the court to give.
All right, thank you. And you're right, Mr. King, that is not inconsistent with Order D46, and this is not a request to reconsider Order D246. Go ahead, Mr. Brockler.
Your Honor, I think what the court has read from Galimanis is consistent with the actual jury instruction that the court is likely to give on incapability of distinguishing right from wrong. I don't have a problem with the court giving that. In terms of whether or not it's required under these circumstances, given the 3 specific items that the court last read from the case, those 3, our position is don't apply here, but nonetheless we don't have an objection to the court giving the instruction to the jury, informing them of what incapability of distinguishing right from wrong is.
All right. Since the defense is asking for it, and since the prosecution has no objection, I will give it. This doesn't necessarily mean that I will give it at the end again, although I well may do that, but we can have that discussion later. But the defense is specifically asking me to give it. The prosecution doesn't have an objection, and I don't think it's inconsistent with Galimanis. Galimanis was simply saying it's erroneous to suggest that it's an instruction that's required, not that it's erroneous to give it in all instances, or that it's erroneous to give it in one particular instance or another. And the parties have a dispute in this case as to what this case involves, and given what the defense believes about this case, the defense has indicated that it believes that this instruction is appropriate, and the prosecution has no objection, so I will give it. The question is, when do I give it so that it makes the most sense? I can think of two different approaches. One is to allow Mr. Brockler to clarify what I have indicated should be clarified, and then to give it to the jury at that point, and to remind the jury first about the applicable test for insanity in Colorado so that it's completely clear, and then give this limiting instruction at that point so that it makes the most sense that way. Or I could give it to the jury immediately when they come back in the courtroom, and then allow Mr. Brockler to proceed with his direct examination and to clarify things with Dr. Reed pursuant to my instructions. Do the people have a preference between those two approaches?
No, Your Honor, thank you.
Does the defense?
I prefer the latter, Your Honor.
Okay.
To have them instructed first and then have Mr. Brockler give him the opportunity to clarify.
All right, and to keep it simple, I'm only gonna read the part of the definition, the test that is relevant at this time, and that is that the applicable test for insanity in Colorado is a two-part test. One, a person who is so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act is not accountable. Or two, a person who suffered from a condition of mind caused by a mental disease or defect that prevented the person from forming a culpable mental state that is an essential element of a crime charged. And actually, as I read it, I'm thinking that it might make more sense to simply read the part of the model instruction that says the defendant was, on the Colorado law, the defendant was insane at the time of the commission of the act if, and then it reads, one, he was so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act. Or two, he suffered from a condition of mind caused by a mental disease or defect that prevented him from forming a culpable mental state that is an essential element of a crime charge. I don't know that we need essential. I think I would just say element. It might make more sense to give the latter as opposed to the former. Do the people agree with that?
Yes, sir.
Mr. King, do you agree with that?
Objection with that.
Okay, that's how we'll proceed. I will read that then, and then I will give the limiting instruction that has been requested by the defense under People versus Sarabo. And then I will give the limiting instruction at that point. All right, are the parties ready to proceed?
No, Your Honor, would the court consider giving that instruction while Dr. Reed is witness stand? That might actually help too.
Yes, I think that's fine.
No objection to that.
Okay, thank you. Let's bring the jury in, please. And before the jury comes in, Mr. Brockler, you have talked to Dr. Reed?
Sorry, Your Honor?
You have spoken with Dr. Reed?
Yes, sir.
Okay, great, thank you. Please be seated, everyone. The record should reflect that the jury has joined us again. Welcome back, members of the jury. I hope you had a good lunch. Good. Before we start, I have a couple of instructions to go over with you. Under Colorado law, the defendant was insane at the time of the commission of the acts if, number one, he was so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act. Or, number two, he suffered from a condition of mind caused by a mental disease or defect that prevented him from forming a culpable mental state that is an element of a crime charged. I know that's a definition that I have given you before. I wanted to remind you of it. That's the definition of insanity. As related to the conduct charged as a crime, the phrase incapable of distinguishing right from wrong refers to a person's cognitive inability due to a mental disease or defect to distinguish right from wrong as measured by a societal standard of morality, even though the person may be aware that the conduct in question is criminal. The phrase incapable of distinguishing right from wrong does not refer to a purely personal and subjective standard of morality. Next, I need to advise you that the testimony you're about to hear from Dr. Reed has been admitted only for a limited purpose. You may consider this evidence only as to the issues raised by the defendant's plea of not guilty by reason of insanity. You shall not consider this evidence for any other purpose. Does everyone understand all those instructions? And people are saying yes. All right, thank you. And remember that at the end of the case, I will give you what are called jury instructions in writing, and each of you will have a copy of those, okay? All right. With that, then, Mr. Brockler, you may resume your direct examination. Dr. Reed, I will remind you that you're still under oath. All right?
Yes, sir.
All right. Mr. Brockler, you may proceed.
Thank you, Your Honor. Sir, I want to be pretty precise with you about a couple different things that you ended up finding in this case, and then we're going to spend a lot of time talking about how we got there, okay?
Sure.
First, is it your opinion that the defendant suffered from or met the diagnostic criteria for a serious mental illness?
Yes.
I know that we're going to talk about what the debate is over what exactly that is, but the next two questions are pretty specific as well. Despite whatever that serious mental illness is it your opinion that the defendant on July 19th and 20th had the capacity to know right from wrong as the court had just defined it for this jury?
Yes.
And despite that serious mental illness, whatever it was, is it your opinion that the defendant had the capacity to form the intent to act after deliberation and to act knowingly?
Yes, it is.
And to sum up both of those prongs, is it your opinion that on the period of time that is applicable to these proceedings, that the defendant James Egan Holmes met the definition of legal sanity?
Yes.
Let's talk about how we got there. Do you remember approximately when you were appointed to reach opinions in this case?
I believe I was appointed in late March of 2014, although I didn't begin work until May.
You begin work in May. Now everybody wants to watch these videos. Everybody wants to know about these videos. When is the very first video of your assessment and interview of the defendant?
July 29 or 30, one or the other, right at the end of July 2014.
Now there's a gap of time there between the middle of May and the end of July. And what I want to talk about is how you approached this particular task that you were appointed to by the state hospital and the court, okay?
Sure.
Once you got appointed, what was the first thing that you did?
The first thing that I did was read the court orders and instructions to clarify the task that I had before me. The second thing was to receive various kinds of records and contact both the defense and the prosecution.
Doctor, there's some water there if you want.
Thank you. So that I could receive as much information and data as possibly available that might be relevant to my task. When those things then came in from both the defense and the prosecution, and perhaps some other sources, I'm not certain as I sit here, and then I began to review them.
Now, do you need a moment, sir? Take your time.
If you don't mind, I'll put a little lozenge in my mouth. That may help a little.
I don't mind.
Please go ahead.
This may seem obvious, and I don't mean the question to sound trite, but why not, as the matter of course, first, just go and visit this guy in custody and interview him?
There's one circumstance under which I might have done that, but that circumstance didn't exist. That is, had I been able to see him immediately after the event, I would have wanted to see him right then. That not being the case, this is sometime later, I need to know what I need to ask him. What do I need to find out from him? How should I examine him? What are the important questions that need to be answered? And where do those questions come from? What's important? What's less important? What's very, very important? The only way I know to do that is to review as much material as I can find of all kinds, and a great deal of material was received, as you know. Talk with a number of people who have been involved with the matter, both prior to the event and since the event, and then plan very carefully how best to examine the defendant in order to complete my part of the task.
Now, in doing that, doctor, did you give yourself a time limit? Like, I'm going to do everything I can in X number of weeks, and then wherever I'm at, that's when I'm going to go do the interview.
No time limit. I didn't give myself one, and had the luxury of nobody said you have to have it done by Friday.
Now, there's a tendency, I think, to want to put some sort of emphasis on these videoed interviews, and in fact, there's about 22 hours of them. Is that fair?
Yes.
And make these sort of the defining piece of evidence in your assessment, analysis, and opinion of the defendant. Is that fair?
No, these are part of what goes into the overall group of things, large group of things that leads one to an opinion. Some things are very important, some things are less important. Some things, once you do them, are pretty much not important. Is it important to see him and see him completely? Of course. Is it the be-all and end-all? Of course not.
Let's set that video stuff aside for just a moment and talk about what you did in the 6 or so weeks leading up to it, okay?
Okay.
You indicated that you received materials from both the defense and from the prosecution. In fact, didn't the defense come down to Texas to bring you a box full of stuff?
I believe they brought things in person, and I know an investigator brought it, and other folks maybe as well. They brought it in person, prosecution shipped it.
And do you have your report in front of you, Doctor?
Yes.
Now listen, I'm going to ask you if they brought some things down. If you don't remember and it would remind you about what was brought down to you, would you let us know? And then I'll ask that you take a look at your report, and when you're done with it, flip it over.
Sure.
And if it reminds you, we'll answer, okay? Do you remember being brought in a bunch of stuff, several DVDs by the defense?
I'm quite sure the defense brought DVDs, and there are lots of DVDs and CDs that I have. Who brought what, I'm not certain of at this point. They all came pretty close to each other.
Would it refresh your memory? Would it remind you of who brought what to take a look at that kind of detail in your report?
It may. Let me take a look at a section of the report
Page 29, Doctor.
that specifically goes to resources.
And Judge, just as a general matter, I don't have any objection to the doctor referring to his report at any point, as long as he can just tell us when he is and what portion he's looking at. Thank you.
Sure.
All right.
This is on page 29, within the subtitle of sources received and/or relied upon in my review. Great. This does outline it. Hand delivery by Ms. Brady, Mr. King, and Mr. Gunglach. And there's a list of things. If you want me to read them, I will. Otherwise, I won't.
Yeah, I'd like to know with some detail. Let me ask you about them, and if
Sure.
you're going to refer to that page 29 of your report to confirm it, just tell us you're doing that, okay?
Okay.
You were brought a DVD that was produced by the defense. Is that fair?
I'm trying to see which ones were actually produced
and
by
Dr.
them, and I'm pretty much continuously referring to my list here.
I'm sorry, Doctor. That first one, that DHM video they took from the PD.
Which suggests to me they took from police department, but maybe that's not the right. The best I can say is they brought that DVD of DHM videos. And I think that stands for, well, I'm not certain what it stands for.
Denver Health Medical?
Yeah, that was my first thing, Denver Health, the hospital.
So the defense brought you a couple of videos that you were able to consider from Denver Health Medical.
Yes, and I'm aware that videos I saw from Denver Health Medical, some of them were produced by the defense.
They also brought you a DVD of some videos of the defendant seemingly falling, and I've used air quotes there, off of his bed over at the jail.
Yes, and those were jail produced, but provided to me by the defense.
Yes, sir. And then there's a whole bunch of physical records, hard copies of records you were provided. Is that true?
Yes.
Can you give us a sense of what you covered there, what you got from the defense?
What I have written is James Holmes' Social History, J.H. Computation Book with transcribed pages, that is, the handwritten pages and pages that were transcribed by somebody else, typed out, J.H. Writings and transcribed pages, report by J.G. regarding collection of these writings, that may be Mr. Gonglak. I hope I'm pronouncing the name correctly. Complete set of current jail records between July 20, 2012 and April 21, 2014. Pod logs, that is the jail pod, the jail area where he was. The logs July 20, 2012 to May 30, 2014. And a letter from Ben Rice concerning Betty Holmes. And that's in the little section called hard copies on that page.
And then if I could, just a couple things. One, that J.H. Computation Book, Doctor, is it your understanding that is what we have kind of been calling around here the notebook?
Yes.
And that was transcribed for you?
It was the handwritten version, copies of it, and transcriptions of each page as well.
In addition to those things you've just described, you also received a number of interviews of witnesses at Denver Health Medical that were done by the defense investigators. Is that true?
Yes.
Also, a series of interviews that were done by the defense investigators from the Arapahoe County Jail.
If those are the medical workers at the jail, Mr. Maldonado, Barros, Fournier, and Sanchez Lopez, that's correct.
And right above there, Doctor, where it's kind of hidden under the phrase Arapahoe
Oh,
County
I beg your
Jail
pardon. I beg your pardon. Yes, Arapahoe County Jail interviews, some 8 transcribed interviews.
And then you've also received from the defense a series of emails containing different affidavits, notes, transcribed interviews, that sort of thing. Is that fair?
Yes.
Now, that's important because I want to ask you, did you consider everything that the defense provided to you, not just leading up to the writing of this report, but even since then?
Did I consider everything in
that the defense has provided you, was there anything that they provided you said, I'm not even going to count that, I'm not even going to read it, not going to consider it?
No, I have read everything that's been provided unless it was lost someplace by my secretary.
Okay. Okay. You were also provided materials by the prosecution, right?
Yes.
Did we give you what we're going to call discovery, and that is reports and photographs and DVDs and CDs in the tens of thousands?
Some 70 or 75,000 pages of hard copy and several hundred CDs and DVDs.
And did you have the opportunity to review and consider all of those materials?
I had the opportunity. Some I reviewed and some I didn't, and I can certainly clarify which things I didn't review.
Please.
Sure. For example, there was box after box of medical records of victims of the shooting in the theater. Those I didn't view as relevant to my task and did not look at. Victim statements, I believe I looked at everything, looked more at some that were more relevant to my task, and spent less time on ones that didn't appear relevant to my task. The jail videos, the jail has a system of 24-hour video observation of Mr. Holmes, no matter what cell he's in. He had been at that point in two different cells. I watched the 24 hours of video for the first 7 to 10 days, I believe. It was extremely repetitive, and I began then to spot check those videos, so I skipped over some days. I looked at the jail logs and the custody notes to see if there might be something in those days that I should be looking for, and I decided it wasn't. So if you ask me, did I look at such and such a jail video, it may have been one of the later days that I skipped. When certain events happened in the jail, such as in November, I looked very closely at those videos. By that time, the jail wasn't keeping every day's videos, as I recall. But there are videos of, for example, the fall. I hope that's responsive to your question.
It is. Let me back up a little now and ask for some clarification.
Sure.
You said you had access to these, sounds like thousands of hours of jail video, and you prioritized it by watching ones that you thought were most relevant, including the first 7 to 10 days at the jail. Is that what you said?
Yes, I certainly watched all the video and then determined that it was low priority to watch it because it was simply repetitions of virtually the same things, and began to spot check it after that.
Tell us, why did you focus on the first 7 to 10 days?
Because I didn't know what he was going to look like in jail, for one thing, and I wanted to clarify for myself whether it was useful or not. The second was the period closest to the event is logically, in my mind, much more likely to be relevant to the way he was on July 1920. As one moves further out from the event, whatever he's doing or feeling becomes less likely to be directly related to the way he was or what he was capable of on July 1920. Hope that makes sense.
It does. Did you make any observations, Doctor, in those first 7 to 10 days of jail videos right after this incident that impacted your opinion about the defendant's sanity, legal sanity?
That certainly were related to my opinions. The answer is yes.
How so?
I don't have the specific notes from that. I did take notes as I watched them. In general, he was appearing pretty much like other inmates might appear. There was nothing psychiatrically unusual going on. Was he exactly like any other inmate? Perhaps not, but there wasn't anything psychiatrically of interest to me going on, which is why I stopped watching every single day's videos.
And when you reviewed those jail logs and those pod logs over that first 7 to 10 days, did you find anything in there that told you that something psychiatrically significant was taking place during that time?
Only minor things, such as not wanting to see a doctor or something like that, as I recall a couple of times. Let me also clarify one other thing so folks understand. The jail videos had no sound, okay? They were merely the picture without the sound. I just want to be sure everybody understood that.
That's fair. So during those first 7 to 10 days of jail logs and pod logs that you've described to us, you didn't find anything that had a significant impact on your opinion as to the defendant's legal sanity?
Objection leading.
It's a follow-up, so I'll allow it overruled.
Pretty much everything has some impact, whether it's toward one thought or toward another thought. I didn't find anything that appeared to me to be relevant to an incapacity, if that's logical. Hope that's responsive once again. I'm not sure.
It is. And you know what? This is probably a good time for me to ask you this, which means I probably should have asked you before. Before you started getting into these materials, what is your mindset about what you're looking for in not only the information you're provided by both sides, but ultimately when you conduct the interviews and the assessments of the defendant? What is your mindset? What are you looking for?
I'm looking for things that suggest or indicate that there may be serious psychiatric issues, behavior or something else that might suggest an incapacity. I'm not looking for what would show he's capable. I'm looking for things that might show he's not capable. I'm not sure that's really clear. Certainly haven't made up my mind about anything at that point, but I know that the issue is, does he have the capabilities and the capacities? So I'm looking for things that suggest he doesn't.
Based on those standards that we've been talking about today, are you looking for evidence of insanity?
Yes.
Okay. In those first 7 to 10 days that we talked about, videos, jail logs, pod logs, did you find something that you believed was evidence of insanity?
No.
And those were the days immediately after the incident.
That's correct. Now, let me separate because I want to be clear. I found things that were oddities or that were interesting, things to perhaps ask about later or learn more about. But there was nothing that said, goodness, this is evidence of or highly suggestive of insanity.
Should we talk about those oddities?
Sure.
What were the oddities?
May I include other videos, or do you want me to stick with the jail videos right now?
When you talk about other videos in your question back to me, Doctor, are you talking about videos outside the context of the 7 to 10 days in the jail?
Between arrest and jail.
We'll get to that.
Okay.
We'll get to that part. I was just focusing you on the jail videos since we had talked about those. We'll get to the other ones, okay?
Okay. He seemed to sleep at slightly odd hours, if I'm recalling right. I can't think of very much else that seemed odd with regard to a video camera that's simply on him. You don't know what he's saying, etc. He eats, he reads, he plays with a hockey sack, or hacky sack, I guess it's called. Seems to follow instructions. Seemingly to me, apparently pretty average stuff.
Do you know about what's called the kite system in the jail?
Generally so.
Based on your review of these logs and pod logs over that same period of time we've been discussing, was the defendant accessing the kite system?
I believe he was, and I think correct me if I'm wrong about what you mean by that. That is, he was asking for things from the library, asking about things from commissary at various times, communicating to jail staff at least some needs.
Now, let's get back to, in general, this giant volume of material that you've been provided, all right, by both sides. First off, can you give us an estimate of how long did it take to get through that in a way that you felt sufficient to move on to the next step in your evaluation?
Prior to my seeing Mr. Holmes in person, or prior to my starting the evaluation, I had done about 300 hours of review. That included review of the things on paper, review of various videos, talking with different people who had had some experience of some kind with him or been involved somehow in the case. Came to about 300 hours.
I want to back up a little bit and talk about some of the things you mentioned in that 300 hours. First off, did you spend time with that notebook and translation that you were provided? Did you go through that thing in detail?
Yes.
Why was it important to go through that in detail before you sat down with the defendant to talk to him?
These were things that he had written down. I was fairly certain that he had truly written them down himself. It's something to ask him about. It would have been sort of silly to see him and then go read it and wonder what he meant. This way I could ask him what he meant, at least as of the time I saw him, having looked at it carefully beforehand.
Was it important to you in your forensic examination to be able to ask him questions about the contents of that notebook?
Sure.
There were some other things you were provided, something called a Google chat, communications between the defendant and someone you later came to know was his girlfriend at the time. Do you remember that?
Yes.
Did you spend time going through the details of those chats?
Yes.
Why were those important to consider?
Once again, they're representatives of what he was doing that may well reflect how he was doing prior to the event. It would have been silly to see him and then look at them and not be able to ask questions about them. The content was of interest, some more than and some less, but it was important to be able to talk with him about them. So as much as I could find before seeing him, I wanted to see, and I probably pestered the prosecution and the defense to get more and more during those 3 months.
There was also some communications that took place between the defendant and another woman in his class after he tells you, and we'll get to this, that he broke up with his girlfriend, or she broke up with him. Did you go through in detail those texts?
Yes.
Why was it important for you to do that before you spoke with him?
Same answer. These are things that are part of his behavior, part of his communication, perhaps reflective of how he's doing mentally prior to the event. And what's more, the ones that you just referred to happened even closer to the event, happened in, I think, June, as contrasted with March or April.
Some other things, records that you have been provided. Did you look for evidence of what the defendant's daily life and activities were like in the period of time leading up to this event?
Yes.
What sort of things were you looking at in the discovery you were provided?
I was looking at how he spent his days and weeks. How was he doing at school? And one hopes not just one version of that, but as many versions of it as I could get. What did this teacher say? What did that teacher say? What did the third teacher say? What did this friend say? What did that friend say or see or write down it somehow? Sometimes I talked to or attempted to talk with some of those people, and they weren't limited to friends, but the whole idea here is how he is functioning in life and in the world and in his world. And I wanted to know as much as I could about that before talking with him in person.
You bring up a point I want to ask you about, and that is invariably in the discussion of the defendant's mental health, we're going to get into a discussion between you and other experts about what a specific diagnosis is. Is that fair?
That's fair.
In your opinion, is the name of the diagnosis what is most important to consider in evaluating the defendant's sanity, or is it what you said before, which is the function that he was able to do despite whatever the illness is?
It's the function. The name of the diagnosis, or even what the diagnosis truly is not the important thing in my view. It's how is he functioning, what is he capable of, no matter what diagnosis he may have.
So in addition to, you talked about reviewing statements and in some cases interviewing people from the school, it sounds like, professors.
Among others, yes.
Did you look at other things too, like maybe purchases he was making, how he was doing outside of school based on other statements or evidence provided?
Yes.
And you considered all that stuff leading up to your discussion with the defendant?
It's all part of the picture of one's life, which is what I was trying to get as many views of as I could.
Now, something else that you were provided the reports, notes, other examinations of other mental health providers. Is that true?
Treating providers is what you're talking about?
Yes, sir.
The answer is yes.
You were also provided the reports of the defense's hand-picked psychiatrist, yes?
Yes.
Objection leading.
Sustained.
Thank you, Your Honor. Can you tell us, in addition to treating mental health providers, were you provided reports from other psychiatrists in this case about the defendant?
Yes.
Can you tell us who?
One was a Dr. Gurr, G-U-R, who's a psychiatrist from Pennsylvania.
Hang on one sec. Who's Dr. Gurr in relation to this case? Who picked her?
My understanding is Dr. Gurr was retained by the defense to be one of their experts in the case.
Who else?
Dr. Resnick, who was an expert chosen, retained by the prosecution. Dr. Metzner,
Who was a court-appointed?
who was a judge's expert. Dr. Woodcock, who was defense appointed, and I'm not sure exactly how he might be classified by them. Just limiting it to physicians, Dr. Mosier, that was a treating person, I'm sorry.
Is Dr. Mosier one of the jail mental health professionals?
Yes.
Okay.
And you were referring to experts or non-treating people, so I would leave him out of this discussion. I think that's all the psychiatrists. I may stand corrected, but I think that's all the psychiatrists or physicians that were not treating professionals.
And you were also provided with reports, or were you provided with reports from other mental health professionals who weren't psychiatrists, like
Yes.
psychologists?
Yes.
Okay. And you had the chance to go through those reports and consider their observations and their opinions?
That as well as the notes that they made to the extent that I was able to get them, yes.
Now, did you just rely on the reports and the notes that they wrote down, or did you reach out to them?
I talked personally with Dr. Gurr, with Dr. Metzner, with Dr. Resnick, with Dr. Woodcock. I think I talked personally with each of them, with every one.
Why would you do that? If you have their reports and their notes, why isn't that enough, Doc?
I want to know if everything that they thought was in the reports. Did they have some new thoughts about it? Had anything happened since they wrote the reports? Sometimes it had been some time since they had written notes or reports. Wanted to have every opportunity to gather information that I could.
Part of being thorough?
Yes.
But it's more than that. I'm looking at your page 31 of your report, Doctor. It looks like there are, ballpark in this, 40-ish people that you personally spoke with about their observations in this case.
I think that's fair to say, including some that were quite brief and some that, for example, members of the defense team and members of the prosecution team. I would say at least 25 or 30 would be people who had something to say about the defendant himself.
Let's talk about some of the specifics of those people.
Sure.
You're aware that the defendant was seeing a psychiatrist for a period of time at CU while he was schooled there?
Two of them, actually, yes.
Did you speak with someone named Margaret Roth,
Yes.
in addition to looking at her reports and notes?
Yes.
Did you speak with Dr. Lynn Fenton
Yes,
about her notes and her reports and observations?
yes,
How about Dr. Robert Feinstein?
yes.
Again, why was it important that you speak with them before you started to opine on this man's sanity?
Because I wanted to go into the examination with every bit of opportunity to ask the right questions and not miss something that I could. Now, as I look down my list here, I'm trying to see if some of those discussions took place after the exam. I believe those all took place before I examined him, or at least before I finished the exams of him.
You also, by the way, did they ever tell you, hey, we don't want to talk to you anymore, or did they answer all your questions?
There were a couple of folks, not the physicians.
And I'm only referring to the physicians we
okay.
just mentioned, Roth, Feinstein, and Fenton. They answer
Of
all
those three, they were very free with their time and very, so far as I know, free with their information.
Now, there's another incident that we were told about in opening statements that took place in November of 2012 at the jail. And you sort of touched upon it too. Do you know what I'm talking about?
Yes,
Did you have the opportunity in preparing not only for your examination of the defendant, but also in formulating your opinion and writing your report, the opportunity to speak with the people involved from Denver Mental Health who addressed that incident from November of 2012?
with many of them. No, I wouldn't say with all of them, but there was an opportunity to talk with some. Some talked with me a bit. Others said, you know, it's all in my report from such and such in the record. But the answer is yes, I had the opportunity.
Now, and we'll get into more detail about if there was, well, let me just ask you. That incident, and we've seen some videos on opening statement of the defendant in a cell seeming to run his head into the wall and seeming to fall off of a bed and being naked in a cell. Have you watched those videos too?
Several times.
And you've had the opportunity to review the things that you talked about in relation to that incident. My question to you is, does that thing that took place in November of 2012, is it relevant to a determination of the defendant's sanity back on July 19th and 20th of 2012?
Generally not.
And we'll get into more detail about that later, but thank you for that. Now, you also reached out to people that were not mental health providers and were not people from CU. Did you reach out to the parents of the defendant?
Yes, I called them and they spoke with me, yes.
Why would you do that?
They lived with him for a long time. They observed him more hours over his life than anybody else.
And did you give them the opportunity to tell you anything and everything that they wanted about the defendant?
Yes.
And you factored all that into your report too?
Into both the report and the preparation to talk with the defendant, yes.
And ultimately your opinion on sanity?
Ultimately so.
You did more than that though too. In addition to all of these interviews that we sort of touched upon, did you go and do something that we could call a site visit?
Yes.
Tell us about that. What does that mean?
It's useful to me and to many people who kind of do what I do to not just read about things and see the photographs, but to go to the site and experience that environment. In mid-July, I came here to Aurora. Believe that's the visit in which I went to the theater, went to the Aurora Police Department. I believe it was Detective Apple who took me through, talked with him a good bit. Did not go to see Mr. Holmes' apartment. It had been redone and re-rented, etc. Did not go inside the theater, which had been remodeled by that time, but went to the outside, kind of saw what the lay of the land was. Went to see what the jail environment was like, got a bit of a tour of the jail environment, saw both of Mr. Holmes' cells, that is both the medical cell that he was in, or has been in, and what they call the BC cell, or the behavioral control cell, sometimes called the hole. Saw that. At that time, as a matter of fact, I believe this was arranged in part by the defense, if I'm remembering correctly. And one of the defense attorneys, it may have been Mr. King, I'm not sure, met me there, and I asked if I could be introduced to Mr. Holmes, just so he'd know who I was and was going to see him sometime in the near future. He didn't know exactly when, and at that point I don't think I knew exactly when either.
Just to be sure, nothing else significant grew out of your introduction with the defendant. It was very brief.
It was very brief, and I purposely wanted it to be brief. I wanted him to see who I was, wanted to shake his hand, wanted to just begin, so it wouldn't be such a huge surprise of coming in to talk with him suddenly. Or the way it works is they put him on a plane and send him somewhere so I can see him. That's a pretty big surprise, so I hope to tone that down a little.
You mentioned you went to the jail. You wanted to see the cells that he was in.
Yes.
Tell us why that's important.
I want to see what the environment is that he's in which he is acting the way he is, whether he's acting normally or whether he's having difficulty and running into the wall or falling backward off the bed. Is it really as described in some of the reports? The video only shows it from one side. Is there a big or small window in the door? What does the exercise yard look like? And I probably should add, just kind of voluntarily, the extent to which those are related to the specific task is relatively small. The extent to which they may be related to explaining or helping me understand how he's behaving in the jail and perhaps how he behaved the first few days in the jail is a big part of why I was there.
Okay. You just wanted to be thorough.
You said it more quickly than I did.
Is there anything else that you did within what you've described as about 300 hours of preparation before you took on the task of getting ready to interview and assess the defendant?
I think we've covered generally what I did. There are lots of details. I can't think of anything. I interacted with attorneys on both sides, with Tanya Wheeler, who is an attorney that was my guide within this process.
From the Attorney General's office?
From the Attorney General's office. Those are the categories of things that I did.
Okay. I will ask you down the road a little bit more specifics about your conversations with Doctors Woodcock and Gurr. But for now, having put that under the umbrella of the 300 hours that you had, was there anything that you wanted to do to be fully prepared that you did not do before you interviewed the defendant and assessed him?
There were probably things that I tried to get, but nothing. There was nothing that said it's not time to interview him. It's not time to examine him. It was time to examine him, and we were able to set that up.
So you're going to start this interview process, it sounds like, late July of 2014. That's just almost a year ago. That's an amount of time after this event. What impact does that have on what you decided to do and how you considered it?
Okay. And I think that's important. I appreciate you bringing it up. I think everyone should remember that my examination, my interviews, and what you'll apparently see on video in a few minutes, all took place some 2 years after the fact. Lots of things had happened between the shootings and the time that I saw him and the time the videos were made. Some of those things were very important, so that what one sees in the defendant on the video is how he was in July and August of 2014, not necessarily how he was in July of 2012. And that's important to know. That's important to remember.
Well, along those lines, I mean, you've indicated that the defendant was evaluated and interviewed by several other psychiatrists and mental health professionals before you. How many of them videotaped their interviews?
None so far as I know.
This is it. This is the only one we're aware of.
By a psychiatrist or psychologist, so far as I know.
Okay. Let's talk about some other things that we need to consider as we begin to watch the video that's done. First off, why did you do it by video if no one else did?
Shouldn't calls for speculation.
Overruled.
Go ahead, sir.
It's important, in my view, to record examinations and interviews that are done for courts and for lawyers. Video is better than audio, and it does several things. Some of it is selfish from my viewpoint. I don't have to take notes. It's on video, and I can watch it later. I don't have to take notes that might be erroneous. I don't have to take notes that might distract me from what the person's saying, or that might make the person think I'm not particularly interested in listening. Another reason is that if someone wants to come back and critique that examination or those interviews, they're right there to see. You don't have to trust what I say. You don't have to trust my memory. I may be as honest as the day is long, and I hope I am, but I don't have a perfect memory. So that it's memorialized, if you will. Another is that sometimes, and I'm not sure this was the case in this particular matter, sometimes lawyers or other people want to be present in the interview. In general, that's a bad thing. That interferes with the quality of the interview and the examination. So that I can say to the attorney, look, you can see exactly what went on, and if there are things that aren't legal from the standpoint of this case, you can take it up with the judge. Reasons like that. It has to do with being sure that everybody can see what the examination was. They can hear what I asked. They can see how the individual answers, what he looks like. It's not hidden. By the way, the video camera is never in my work hidden from the individual. It's not surreptitious or hidden camera stuff. The camera's right there. I tell him that it's right there. He understands it's right there, and he can see it. The way I usually do it, maybe I'm going on a little too long, but the way I tend to do it is to have the video set up and the videographer steps out of the room so that the examinee and I are the only people in the room. Now, sometimes people are watching through glass for security purposes or something like that, but they can't hear what's said and they can't see the face of, in this case, the defendant.
That's a lot. Let me break up a couple of those things. One, what you said you like to do is to have the videographer step out of the room while you and the camera and the subject, the defendant, are talking. Did that happen in each of the 9 segments that you recorded?
Yes, it did. He stepped out of the room.
There's nobody else in the room.
That's correct.
Let's back up a little bit. You remember there was reference to a guy named Dr. Woodcock. Do you remember that?
Yes.
Now, Dr. Woodcock is a psychiatrist?
Yes.
Do you know when he was able to see the defendant in relation to the events that we're here to talk about?
Within 2 or 3 or 4 days of the events. It's not clear to me. I think it was with 4 days. It could have been even sooner.
Did he videotape his interview?
No, he did not, to my knowledge.
Did he have somebody present in the room with him when he conducted his interview?
Yes.
Who?
Mr. Bishop, who's an investigator with the defense team.
The defense investigator.
Yes.
You know, as long as we're talking about Dr. Woodcock, and I promise we'll get back to the video stuff because I want to play it. In your review of Dr. Woodcock's notes, and by the way, did he write a report after that interview with the defendant?
Some months later, he wrote a report.
And we'll get to it.
At least months, yeah.
Forgive me. By some months later, you mean about 2 months ago?
I think it was March 2015 was the first report, if I'm remembering the dates right. I could have that wrong.
Okay. Prior to a couple months ago, had he generated a report about his interview with the defendant?
Objection asked and answered.
Overruled.
Go ahead, sir.
Not to my knowledge, at least not one that I received. I asked for reports and notes. He had notes, but I didn't receive any report dated earlier than his first report, which was in March.
And based on what you've said before, it sounds like you certainly considered what he put in his notes.
Sure.
Did you call him to follow up and ask him questions about those notes in that interview?
Yes.
All right, first off, how long was his interview with the defendant shortly after the incident?
My memory says 2.5 hours to 2 hours and 45 minutes, something like that.
And based on those notes, and your conversation with Dr. Woodcock, did he ever tell you that he thought the defendant lacked the capacity to know right from wrong under the standard that the court read to the jury earlier today?
I don't recall his ever using those words, no.
Did he ever say that the defendant lacked the capacity to form the intent to act, to deliberate, to plan, or to act knowingly?
No.
Did he ever tell you that it was his opinion after that 3-hour interview with Mr. Bishop present shortly after this incident that the defendant was legally insane under the standard for Colorado?
No, he never said that to me.
Or in his notes?
That's correct.
Okay. Let's go back to the videotape stuff. There are other things to consider before we watch this that help us put this in perspective. And what I want to ask you is this. Is there an impact to what we're going to see from the defendant having been in relative isolation since he was taken to the Arapahoe County jail after this incident?
There is no doubt some impact.
What sort of impact, in your experience, would there potentially be?
Objection. Foundation.
Overruled?
Go ahead, sir.
Is this within your area of expertise, Doctor?
Yes.
All right, overruled.
I apologize, Judge.
The short answer is I don't know what the specific impact or impacts are. There are a number of considerations, which I think is what you asked, what might they be?
Yes, sir.
One is isolation frequently makes mentally ill people worse. On the other side of that coin, for some severely mentally ill person, the structure and stability and predictability of being in isolation in a jail may help him stay stable. Some jails, by the way, are very confusing places. My understanding of where Mr. Holmes is and was in the jail is not very confusing. It's quite stable. Would you re-ask your question so I make sure I'm answering your question?
Yeah, you were on it, Doctor, and that was what other considerations that might impact what we're perceiving up here in these videos comes from this relative isolation that he's been in since approximately July of 2012.
From the isolation per se, those two possibilities kind of cover it. There are other things to consider between July of 2012 and July of 2014.
Well, if they're important to our appreciation of this video, please tell the jury what they are.
Sure. One is that other things have happened in between. He had a serious mental and physical breakdown in November of 2012. That's a pretty important event. Another thing is the passage of time has happened in which people's memories can certainly be affected. People's views of what happened can be affected. A third thing, and an important thing, is that he has been taking medication since November or December of 2012, medication generally intended to help him structure his thinking and to not be depressed.
Can you tell us what the prescriptions have been and then characterize the dosage for us?
Okay. He had no medication up until November, December, the event of the falling and things. Once he went to Denver Health, he received one kind of medication called an antipsychotic medication. It's not for any particular diagnosis. It's for symptoms of lack of contact with reality. The one that he began to take then and is still taking, so far as I know, he was when I saw him anyway a year ago, is risperidone, R-I-S-P-E-R-I-D-O-N-E. The trade name is Risperdal, R-I-S-P-E-R-D-O-L. He's taking or at the time that I saw him, he was taking a fairly low dose of that. Not an unusually low dose, but a fairly low dose of that. He, since that time, had also taken an antidepressant called Lexapro, L-E-X-A-P-R-O. The generic name is escitalopram, E-S-C-I-T-A-L-O-P-R-A-M. It's designed in part for anxiety, but I think in his case primarily for depression, based on the record, in a low to moderate dose. He also has taken, and perhaps was still taking, medication intended to treat the side effects of the medications at a low dose. And I'm trying to think which of the ones it may have been, one called Cogentin, Cogentin. I'm not remembering what that medication might have been.
The pace
There may have been one or two other medications for non-psychiatric things. I'm just not remembering.
like maybe allergies or infections or something?
Something like that, or stomach or something.
Okay. Now, those, when you talked about the potential side effects that they try to treat with other medications, what sort of side effects would the defendant be at risk for these low doses of these drugs?
At the dose that he was taking when I saw him, one of the side effects would be a minor tremor, a minor shake in your hands. It's unusual at that low dose, but it happens to some people. Another is a sort of restless feeling in the legs. There's a word for it, akathisia, A-K-I-T-H-E-S-I-A. But mostly it means an odd, restless feeling in the legs, like you can't sit still. Another is one that wouldn't be addressed by the medication I'm talking about, is a sleepiness. That almost always passes very early when one starts the medication. You don't get sleepy after that. Those are the things one looks for. There are a few rarer adverse effects, but those are the things one looks for. Weight gain is one that's common over a period of time if one is taking the medication as prescribed.
You had these 22 hours or so that you assessed and interviewed the defendant that are on video. Those first three things that you talked about, those potential side effects, did you ever observe those? The tremors, the restless leg, and...
Sleepiness? No. He appeared to be, from my view of him, free of side effects of the medications, except for one, which I bet you're going to ask me about right now.
Did you think I was going to ask you about weight gain?
Yes.
Okay, how about weight gain?
And I don't mean to be smiling. This is a serious time. I apologize. He appears to have gained some weight. There are lots of reasons people gain weight: lack of activity, overeating, and these medications. It is likely that the weight he's gained is at least partially related to the medication.
It affects your metabolism.
It's an effect on the metabolism, yes. It doesn't make you eat more so much as it affects the way you manage the fat in your body.
Along those lines, there are some things that you do throughout these videos from time to time where you appear to be taking the defendant's pulse and you look at his eyes. Mm-hmm. We're going to see that in some of these videos. Tell us why you're doing that and what you're looking for.
One of the things that people have noticed, including me, in the defendant, is his pupils, the pupils in his eyes, are often very, very large, unusually large. Sometimes they're not, but they often are. And I wondered why they were that way. I still don't know why they were that way. But from time to time, I would notice whether they were large or small. From time to time, I would wonder whether his pulse was sped up as if he were anxious, as if he were nervous. The actual testing of his eyes had to do with the eyes, the pupils are large. I wonder if they do what normal pupils do, and that is react to light. Do they get smaller when you shine a light in the eye, just like your doctor does at the office? And there's another test for whether they react right, and that is, do they get smaller when you look at things close up? As you look away, and then you look close up. I'm sorry, they constrict. They get smaller as you look close up. So one has him look far away, and then quickly look at your finger or something close up, and you see if the pupil gets smaller. And so that's why I was doing that. A sort of a curiosity, but part of being thorough in the exam. These were unusual characteristics of him. I wanted to explore them as best I could.
Well, now you got to tell us what happened when you did that stuff with his eyes, with the light and had the object close up.
His pupils did react to light. That is, they got smaller. They didn't get as small as one would expect, but they did react to light and get smaller. They also reacted to looking far away, looking close up, which we call accommodation reflex.
Is there anything about those observations, either with his eyes or the pulse, that was psychiatrically significant to you in assessing whether or not the defendant was legally sane?
In retrospect, no, and I can't think of anything something that might have been, unless there'd been something terribly wrong with his brain, and there's no indication of that. I'm sorry to make it such a long answer, but it turned out that it was not related to whether or not he was sane.
Now, one of the things that you had mentioned just prior to this was that the defendant had been on certain medications that were prescribed starting in roughly November, December of 2012. Do you remember that?
Correct.
Is the fact that he has been prescribed those drugs, what relevance does that have to whether or not the defendant was legally sane back on July the 19th and 20th of 2012?
Little or none, because what we want to know is how was he functioning in July 19 and 20 of 2012. What his symptoms were later, whether the diagnosis is the same or diagnosis is different, has to do with how he's functioning later, not in July of 2012, which is my task.
Your Honor, I know the court's going to want to take a break in a moment, but if I could just lay the foundation for these, if the court would permit me to try that, and then if we take a break and come back, is that what the court wants to do?
Yes, please.
Do you want to say him again? Do you want to touch him? Okay. May I approach the witness, Your Honor?
You may.
Hey, sir, I'm going to hand you two different DVDs. One is marked Exhibit 1003, and one is marked Exhibit 1004. Take a look at those. Do you recognize them?
Yes.
And do you know what they contain?
They contain, the first one contains the entirety of the video made of the first session that I had with the defendant. The second one contains a slightly redacted version of that, of the second session I had with him.
All right, and to be clear, you had 9 sessions with the defendant?
Yes.
And roughly how long did each session last?
Between an hour and a half and a little over 3 hours.
And the first session that you had with the defendant was on what date?
I'm going to read it from here if you don't mind. July 30th, 2014.
And you did that where?
That was at the Colorado Mental Health Institute at Pueblo.
Is there anything significant about the location of the video we're about to talk about and show after the break that the jury needs to consider?
Colorado Mental Health Institute at Pueblo, sometimes called SIMHIP, I think, is a secure hospital run by the state in which the interview facilities are a bit more comfortable than in most jails. And I think it was my request that he was transferred there for the first set of interviews. I wanted to see him outside the jail. There's not much more to it except that it was a good room to interview him in, and everybody was very nice.
As a last thing before I move to admit this video, is there anything else that the jury ought to be considering before they start watching this thing?
I've already mentioned that it's 2 years after the fact, bear that in mind, and I think that's the important thing.
Okay. Your Honor, I'm going to move for the admission of People's Exhibit 1003 into evidence, and looking at the clock, Your Honor, I think I'll hold off on 1004 till tomorrow if the court's all right with that.
All right, is there any objection to P-TR-1003?
Judge, we would just maintain our previously stated objections.
All right, based on my previous rulings, P-TR-1003 is admitted and may be published, but we're going to go ahead and take our afternoon break first. Members of the jury, it's about 7 minutes after 3. It's time for the afternoon break. Please make sure that you follow each and every one of the advisements I've been giving you throughout the trial. Enjoy the break. I'll see you back here in 20 minutes. Thank you.
That's all right.
Please be seated, everyone. The record should reflect that the jury has exited the courtroom. Now, and Doctor, why don't we have you go on break as well? So you may step out, please. Thank you. All right, the record should reflect that Dr. Reed has now exited the courtroom as well. I wanted to ask you, Mr. King, whether there was anything else you're asking from the court in terms of the two concerns that you raised before the lunch break and then right after the lunch break. In other words, is there, I gave the limiting instruction that you requested pursuant to People versus Saravo. Is there anything else that you're asking the court to do with respect to that issue?
No, Judge, with the understanding that I did make the objection and the court overruled my objection, so.
You're not waiving your objection, but the question is limited to whether you're asking me to provide any further clarification.
No, sir.
All right, and then with respect to the other issue, the issue of whether the word prevented implies something improper. I ordered Mr. Brockler to clarify that with Dr. Reed. I believe he did, but is there any further clarification that you're asking the court to provide the jury directly with respect to that issue, or that you're asking the court to order Mr. Brockler to do through questioning?
Not at this point in time, Judge. Thank you.
Okay, great. Thank you. All right, is there anything we need to talk about at this time on behalf of the people?
Only logistically. This first segment last. Thank you, sir. Only logistical, Your Honor. This first segment lasts in its entirety about an hour and 50 minutes. And we wouldn't get done by 5 if we tried to play the whole thing here. So I guess what I'm asking from the court is some guidance on, do you want to see if they want to stay late enough to get through that first segment, or do you want me to find a place that closely gets us to 5 o'clock?
I'll ask the jury if they can stay a little bit late. It would require them to stay till, if we start, if we start at 3:25, it would require them to stay until about 5:15. So I will ask them, and depending on what they say, that's how we'll proceed. Okay?
Yes, sir.
All right. Anything on behalf of the defense?
No.
All right, thank you. I'll see you after the break. The court will be in recess.
All rise.